Captioned, INEC asks appeal court to set aside judgment on temporary voter cards. Now, INEC has approached the Court of Appeal Abuja asking it to set aside the judgment of the Federal High Court, which ordered it to allow electorate with temporary voter cards to vote in the governorship and state assembly elections billed for Saturday, March 18. Now, in the suit, the electoral body applied for an order of injunction against execution of the judgment delivered on March 9, directing them to allow the respondents to use their temporary voter cards in lieu of the permanent voter cards for the 2023 general elections, pending the determination of its appeal. In its 3 grounds of appeal, INEC held that the Federal High Court Abuja erred in its judgment when it dismissed its position that allowing use of the TVC would amount to a usurpation of the powers of the National Assembly under Item 2 of the concurrent legislative list. It faulted the trial court for declaring that PVC was not mentioned in the Constitution or the Electoral Act as a condition to be allowed to vote, or as the only means a voter would be entitled to be verified, accredited, and to vote. Annexed, quote, by combined provision of Section 47(1) and 2 of the Electoral Act 2022 and Paragraph 5, Sub 5 of INEC Regulations and Guidelines for the Conduct of Elections 2022, a person is eligible to vote at an election conducted by the Commission if he or she presents a valid PVC at the polling unit in which he is registered as a voter. It further argued that by virtue of Section 18.3 of the Electoral Act 2022, the intendment of the lawmakers is clear for the effect that a PVC is the only valid instrument for voter accreditation at polling unit with the use of BVAS machine in elections. Now, the electoral body added that the whole essence of the manual and guidelines was defeated by the decision of the trial court when it embarked on judicial legislation and jettisoned the relevance and import of the said manual and guidelines, which prescribed in detail accreditation and voting procedure with exclusive use of PVCs. Now, remember, Justice Obiora Egwatu of the Federal High Court had in his judgment ordered INEC to allow 2 aggrieved registered voters, Mr. Skoforola Olusegun and Wilson Orwell, to take part in the elections with their TVCs. The trial court held that evidence before established that the plaintiffs were duly registered with their details captured in INEC's database. It therefore issued an order compelling INEC to allow them to vote during the forthcoming elections using the TVC issued by the electoral body, having been duly captured in the National Register of Voters database. Well, I'm asking you at this time, what would be the impact of allowing the use of TVC in tomorrow's elections, if that does happen, that is? I'm not saying it has. I'm not saying that's the case. But if that happens to be the case, or if it does happen, what is supposed to be the impact? Let's get your take. Via WhatsApp on 0809 030 6416. Reminder, not taking calls on the show today. Also via Facebook and Twitter at Nigeria Info PH. But via phone, I've got joining me right now Barrister Richard Wokocha, Associate Professor of Public Law at the Rivers State University, former Chairman Nigeria Bar Association, Amok Branch. Barrister Wokocha, good evening to you. Welcome to Hard Facts.
Good evening, Doctor. Thank you for having me. Good evening, Nigeria.
Now, Barrister Wokocha, we've discussed this matter in some detail before now. When the first court of instance delivered its judgment, ordering that INEC should allow those 2 respondents use their TVCs for the election. So we will not delve into the matter in detail, especially also as it's before the appeal court at this time. So we'll limit, the depth to which we'll go as far as the substantive matter or the appeal itself is concerned. However, let's touch on elements, of this thus far, and also the impact of a possible scenario where the appeal court does not deliver a verdict. And let's note as well that the election is tomorrow, less than 24 hours from now, very much less than 24 hours actually. But let's start with the matter of judicial legislation, which is one of the points that INEC raised as in its defense or on the appeal it filed. Can you speak to the matter of judicial legislation? And is judicial legislation anti-legislation? Is it anti-law? Is it anti the Constitution? That's presuming, not conceding, but presuming that the judge in the first instance exercised judicial legislation.
Well, when that legislation is used, people refer to the idea of to complete of the law, and therefore mounting as it were to a new law, creating a new norm as it were from what it is interpreting. It's not in the law. So that's what is referred to as judicial legislation that we talk about. Is it anti-people? Not necessarily. The Constitution itself says the courts are to determine what it means by whatever it says, and it is the province of the courts to determine any dispute as to what. So in doing their work, they are not pro or anti the people. They are expected to define what the position of the law is on an issue by looking at the terms used in the law and stating what the law means, and therefore which side
are contrary to existing law, and by virtue of the court's pronouncement or judgment, that existing law ceases to be law, and then the court judgment becomes the new law, in a manner of speaking. Haven't we had such scenarios?
We have had scenarios where the court gave judgments affirming positions that appeared to be inconsistent with the letters of the law as far as English language is concerned. We have had those scenarios where we said this amounts to legislation. I'm not sure we need to go into much examples, but I mean, an example on point is the issue of how we change our names and the decision that it has to be done in a particular way when there is no law on name change. There is no law stating a particular way that name is to be changed. So in that case, yes, we had a new norm. We had the court presenting an interpretation that amounts to a new legal way of doing a thing that is not provided for by law. And we've had some of those cases, but it's not all cases that are on the same platform or on the same pedestal.
Barrister, the governorship and state house of assembly elections is tomorrow. Recently, a court gave an order that two persons who went to court, asking the court to grant them the relief that they should be able to use their TVCs for the election tomorrow, and the court agreed with them that they should be able to use their temporary voter cards. INEC has filed an appeal. As we speak, I'm not aware that the appeal court has determined that appeal. As we speak, this very moment, except the situation has changed in the last minute or on the last few minutes or so, but as we speak, I'm not aware there's been any position reached by the appeal court. If that is the case as we speak and the appeal court has not reached a position yet on the matter, what is the law now? What is the status quo as far as the use of TVC in tomorrow's election is concerned?
For him vote, pending when he is issued his permanent card. So I do not understand what should be the troubling issue. We want that will cause INEC to want to go on appeal, which they have done. So the position of the law is as stated by the High Court that a person who possesses temporary voter's card, especially the two gentlemen whose case was being decided, that since they are duly registered and they possess their voter's card issued by INEC.
Barrister Wokocha, please hold that thought. We have to go for a commercial break right now. Be back in a bit.
Worship your Maker.
In Foodher Port Harcourt, I'm Dyer. 28 minutes gone past 5 o'clock. Discussions continue. Many thanks for staying tuned. And the matter being discussed right now. INEC asked appeal court to set aside judgment on temporary vote counts. My guest is Barrister Richard Wokocha. Has joined me via phone. Barrister Wokocha, you're welcome back.
Thank you, Dyer.
You can also join the conversation. We're live on Facebook and Twitter at Nigeria InfoPH. Also sending a message via WhatsApp on 0809-030-6416. Not taking phone calls on the show today. So, Barrister Wokocha, you were responding to a question I asked you before the break, which once again is, what is the status quo at the moment, considering that I've not heard the appeal court has reached a decision on the matter? What is the situation right now as regards whether or not those respondents can use their TVCs tomorrow?
The status of those people is that they are voters duly registered. The position expressed by the court is the position. I am not aware that INEC has obtained an order staying execution of that judgment of the High Court. That being the case, those people are entitled to vote and they enjoy the benefit of their case by voting tomorrow. It will be going against judgment of the court if any attempt is made to prevent them from voting. They are duly registered voters under the law, whose data are in the BVAS, and in the printouts, physical printouts of voters register that is to be used for the election. So preventing them will be an infraction of their right to freedom of participation in the electoral process.
Before the break, when you were responding to the question, you were saying something about how you don't understand why certain persons. I expressed the fact that I do not understand why you need an appeal over this. The card is issued by INEC. Why was it issued? To identify them as persons duly registered to vote, qualified to vote, and who have met all requirements to vote. The requirement for voting is registration if you are a qualified citizen. And they have been duly registered. INEC confirmed that by issuing an identification card identifying them as voters. It is called temporary voter card. It is not the word temporary that is critical. That card is for voting. INEC called it temporary because INEC has intention to replace it with a permanent one. But the purpose of issuing that card is another vote. That's why it's called voter's card. So I don't understand why they will want to go on appeal to say that persons duly registered by them, not by a different entity. Persons whose data and all information are available, who have been advertised to the world as voters for the purpose of the election, should not vote because INEC has not been able to give them a permanent card, while it has given them a temporary card for voting. I don't understand what the labor department are advising them. All right. Also, hello, Barrister, are you still there? Barrister Wokocha, are you still there? Barrister Wokocha, can you hear me? Well, we have to go for a break now. We'll return shortly. Conversation will continue. Do please stay with us. temporary voter count is what we're discussing right now during the conversation. What do you suppose might be the impact if the appeal court does rule, or rather, if the situation is that TVC is allowed tomorrow? Let's get your take via Facebook and Twitter, Nigeria Info PH. Also, WhatsApp on 0809 030 6416. The issue was the comment on this. Just means contradictory or contradicting that of the High Court. The initial judgment applies, correct me if I'm wrong, please, but I suppose the initial judgment applies not to every eligible voter with a TVC, but only those two persons who had gone to court. Is that correct?
That was the language of the court, because there was a prayer seeking that to be applicable to everybody. But the court distinguished the situation by saying that they didn't show in representative capacity. So it can only grant them the judgment they pray the court without granting to some other people who are not party.
Now, if that remains till tomorrow, if that situation remains tomorrow, and these two persons get to their polling units and present their TVCs and they're allowed to vote, what happens if other persons with temporary voter cards present their TVCs as well?
It means that INEC can behave as if their wrong interpretation is still applicable to such persons. But it will be direct violation of the rights of those persons, clearly a violation of their rights, having been duly registered. It's INEC that is owing them a permanent card, but they have a card issued for voting. So they have the right to vote and also be allowed to vote. So INEC will be robbing them of their citizenship rights to participate in forming their government if it prevents them from voting.
Now, INEC has gone to court asking that the court, I'm using my word right now, I believe,
yes,
it's to suspend the order of the earlier order of High Court when it's appealed, pending the determination. Okay, I'd like to read that. In the suit, the electoral body applied for an order of injunction against execution of the judgment delivered on March 9, directing them to allow the respondent to use their temporary voter cards in lieu of the permanent voter cards for the 2023 general elections, pending the determination of its appeal. Now, if this injunction is granted, that INEC is seeking is granted, I mean, the election is tomorrow. Wouldn't that have denied these persons the possibility of using their TVCs? If INEC is saying, because these persons have gone to court saying that they want to be able to use their TVC tomorrow. INEC is appealing that, saying that the court should suspend that earlier order pending the determination of its appeal. Obviously, the appeal would not be heard tomorrow, definitely. If INEC gets this injunction and the earlier judgment is suspended, so to speak, until the appeal is heard, doesn't it mean that these persons have been denied, that they've been denied justice one way or another, considering that after tomorrow, the matter may become merely academical, at least for the person who went to court originally? Precisely.
Yeah, that would be the case. But the question is, that injunction has not been granted, has not been granted, and there is a subsisting judgment of a court of competent jurisdiction. Tomorrow is not a day on which the court can sit and grant injunction. So if INEC does anything to the contrary, it will be acting inappropriately and illegally, because the court has affirmed the right of the persons affected to vote using their card, their voter's card issued by INEC. So INEC cannot use the fact that they have challenged it to refuse them to vote. If they do so, they will do so at their peril, and those gentlemen will be entitled to recover damages against INEC.
Now, I don't know if the matter is going to be heard today or is being heard today on the matter today. However, shouldn't the appeal court have considered that because the election is tomorrow, shouldn't it have expedited the process, its proceeding somewhat, and then to ensure that it's able to reach a decision before the election tomorrow?
It depends on when the process was filed. The court can do everything possible. There are things that can abridge within the law, but for a process that the other party needs to be had, there is no way you can just do it within those few days, because the law provides a time frame within which they have to respond to what you are bringing. So if you file for an injunction, I haven't seen the process, whether it's an interim application. If it's an interim application, that is 1 days party, which the court is required to make pronunciation on before the other party will be served, and before they will be given opportunity to be heard in a motion on notice to be paid. But if it's a regular motion on notice, that they need to be heard, and there is no way you can abridge it. You can get that between the filing date and the date indicated in the rules for hearing such motion when all the parties have filed their response.
Oh, by the way, you can join the conversation at this time. Once again, send in your comments or questions via WhatsApp on 0809 030 6416. We're not taking calls on the show today. Also join in via facebook.com/NigeriaInfoPH. Also via Twitter at NigeriaInfoPH. Well, I've got a few questions here already. Let's start with this one. If drivers can drive with temporary driver's license and banks can identify customers with temporary NIN card, why can't we vote with temporary voter's card? Do you see that INEC is one of our problems in this country? That's Richard from Rumaolu. Good evening, Dio and Professor Wokocha. I'm personally with the litigants on this issue. After all, we used this very TVC and the 2011 polls, and it's the same register we use till today. However, when we consider that the accreditation process includes the BVAS identifying the PVC, how would such TVC holders be accredited? And that's in text. Barrister Wokocha, I know you're not with INEC and you've not been appointed as spokesperson of the commission either. However, you had an interesting perspective to this last time we discussed the matter, and I think that might help the sender of this comment.
The INEC does not issue TVC until you have been captured, fully registered. The issuance of TVC is an issuance of a certification that you are a fully registered voter who can vote. That is why that card is called temporary voter's card. It is voter's card, but the appellation or the prefix temporary is given because INEC has the intention of giving you a more permanent one. So it is not the card that qualifies you to vote. It is the registration. The card is evidence that you are registered. All persons with TVC have their name and data in the BVAS. All such persons have their name displayed at the point where you will identify your serial number to enable them to do what they have to do with you. So they are not adding anything. It doesn't mean that a person bearing TVC has to have his name written in by ink or something or added. No, those information are already there. They are putting you taxes for the election. Whether them for the you have displayed to the world their data saying that these people are duly registered voters and are expected to vote. And you are now arguing that the card you gave them because you have not given them the permanent one. They should not vote until you give them the permanent one. Is it the plastic that is qualifying them to vote, or the fact that they are registered according to law as citizens who are qualified to vote? So I think it raises no such problem because these names are where your own names are as voters. All the information required for them to vote are there. If they are snapped the delivers or they use their thumbprint, it will show that they are registered voters. Their image, biometrically taken image, will show. If they type in the code on the voter's card, their data will come out for them to vote. It doesn't require adding them as an additional labor or an additional task that will compromise the process. No, these names are already there, displayed as voters.
Also, via WhatsApp, what about temporary driving license? Don't people drive with them until they issue permanent one? That's Wilson who sent that in. Also, don't you think that if citizens see a High Court judgment to stand, that it might cause crisis if BVAS is unable to accredit TVC for the voters? That's from Victor. Barrister Wokocha, your thoughts on that?
The BVAS does not accredit cards. It's not a card reader. We are beyond the card reader system where you insert the card like ATM card and the information in it is read. We are using a bimodal accreditation system. They take a photograph of you, the live person, and it identifies you if your data is in the BVAS. Or they use your thumbprint if that one doesn't work, either of them, and your data will come up. The purpose of the card is to get your registered voters code, which they will insert to bring out the remaining data to enable you cast your vote. It is that same thing in your temporary card, if you still have your temporary card. It is the same number that is in your permanent card. It simply contains your registration number. So they are not using the card. They don't have to slot the card into the BVAS. No. The BVAS identifies you, the live person, either through your thumbprint or through your face. The card only contains your code, which will be added to complete the generation of your database, your data with which you will vote. So there is no such problem, not under the current voting system.
Also, during the last presidential election, I did not see the use or the importance of the permanent voters card, apart from checking my name. The rest was done with BVAS, so temporary voters card can equally be used. BVAS is the key. It checks if you are the actual voter. Francis Okureke said that. I think BVAS uses only the number on the PVC, which is also on the TVC. So why not allow the TVC? That's some Christian. That judgment exposed the lack of adequate homework of INEC. BVAS does not have to read voters' card, as like the previous card reader. Every registered voter should be allowed to vote. Akunda Moses sent that in. On Facebook, Ben Barnabas Carter goes, temporary voters card. Is that difficult for INEC Nigeria to understand? Temporary means it can be used in place of original. And back to WhatsApp. Last election, someone in front of me voted with TVC. Barrister Wokocha, if the claim of this person is true, I've got a message here via WhatsApp. Someone saying that someone used a TVC at the polling unit in the last presidential and National Assembly elections. If that claim is true, and that person not only got accredited using a TVC, but was allowed to vote as well, would that have been a legal vote?
It will be a legal vote. It will be a legal vote. That card, as I said earlier, is a voter's card. It's for voting. It is for a voter, a registered voter to use, pending when he is issued the permanent one. So no law would have been violated if a person with temporary voter's card votes. That year when the registrations were done, I think that was late 2010 or thereabout, moving up towards the 2011 election. I voted with my temporary voter's card. The content is not different from my permanent voter's card difference. The only difference is that one is laminated, while the permanent one is in a plastic. So there is no difference.
So once again,
no law is breached by use of TVC.
So why then do you suppose INEC is insistent? I mean, once again, I understand you're not with INEC and you're not INEC spokesperson, but why do you think INEC is insisting on not allowing TVCs and insisting it must be PVCs or nothing else?
I can't help but wonder, because the same INEC just registered qualified Nigerians to vote who turned 18 before the election. So did they register them with intent that they should not vote? We're not talking about people who have not been registered. These are duly registered persons issued voter's card, which is a card for voting. It will be interesting to see what argument they will present to the appellate court to confirm that because the judgment of the court has not made any new law, neither has it changed any law. The law says a citizen who is qualified who is 18 years must register, and when duly registered, he will be issued voter's card with which he will vote. The process as spelled out in the law is that you will go present your voter's card. Your voter's card is your voter's card, whether it is temporary or permanent. It is your voter's card that is required to be presented. And INEC issued you that because at the date they registered you, they did not yet have your permanent card to give to you. So why should that be an issue? No law is breached. No new law is made by that judgment. The court simply affirmed the fact that temporary voter's card serves the same purpose as permanent voter's card, and a holder of temporary voter's card is entitled to vote just like a holder of permanent voter's card, affirming that the law requires that you should be a voter with a voter's card, and it satisfies the voter's card that is written in the law.
Barrister Wokocha, if I may venture a thought here, from your explanations thus far, and from my understanding of the situation as well, one could even argue that with the inception or the introduction of BVAS, the cards serve almost maybe not entirely, but almost no purpose. What I mean is this: if I'm a registered voter, I could simply show up at my polling unit, stick my finger on the relevant spot of the BVAS. If the BVAS reads my fingerprint, my image and my credentials pop up, and that's it.
Yes.
I'm the one. Then I'm allowed to vote. Or if it scans my face, identifies my face, and identifies that I'm the one, I'm the person, displayed there, I could be allowed to vote if I have some other form of identification. If I have maybe a NIN or or my national ID card or a BVN or something of that nature, I could be allowed to vote.
I think that is how sophisticated the BVAS is, because the code they are taking from the register is already in their possession. They issued you that code. So that code they collect from your the last 4 digits of your voter's card is their own property, which is in their possession, which should be part of the data available there. So it's sophisticated enough for you to be able to vote, even without that. So there shouldn't be a quarrel with whether your card is permanent or temporary. It is not the status that matters. It is whether it is a voter's card entitling you to vote. I think that appeal is one that is not necessary, but the court will determine that. It's already before the court, as we understand.
Oh, we have to leave the matter on this note. Many thanks for listening in, and thanks to my guest, Barrister Wokocha, is former chairman, Nigeria Bar Association Amok Branch, and professor of public law at the River State University. Barrister Wokocha, many thanks for your time.
Citizens, which is Ayo. Thanks for having us.
A commercial break comes up shortly. Top of the hour, 6 p.m. is the major news. Stay tuned. The conversation continues shortly.
Nigeria Info,
the hub for information,
current affairs, and more.
The president used his last Democracy Day address to talk about several issues, including security.
It is this same government that they started